Good morning. Today, Meet in the Middle is bringing you City Manager Brian Maxwell, City Attorney Don Glywowski, and Council Member Craig Brown, Dr. Craig Brown. Now, Brian, we are here because recently there was a lawsuit that made the newspaper that had been in the works for quite some time. Before we talk about the verdict, can you give us the background on exactly what when the lawsuit started, which was essentially, I think, in the Joe Jaworski era.
Right.
Although we don't want to lay this at his feet because, that's very tenuous. But that's about the period of time, 2012, when all this went down. Can you describe those events?
Yeah. I mean, basically, and kind of unfortunately, the lawsuit and the cause of action in the lawsuit predates any of us that are here today. So we're all kind of dealing with it as it falls out. But to dumb it down in terms that even an Aggie can understand, basically what happened was after Hurricane Ike, HUD, and at that time through the TDHCA, Texas Department of Housing and Community Affairs, had a program for the rebuilding and repair of homes damaged after Hurricane Ike. And those homes would have been people who were of low to moderate income levels. This money was tied to our other recovery money that the city would receive, not unlike it is with any other city. The program called for us to hire someone to administer the program. Obviously, the city was not in a good place after Hurricane Ike. We were operating out of temporary buildings. We were having to lay off employees. So certainly repairing homes, while we wanted it to occur, was not something that was high on the city's list. We were trying to get our sewer system working and our water systems working. But anyway, we hired what we felt was a professional firm to handle this. They certainly presented themselves to be that way in Camp Dresser and McGee, which is CDM. The city hired CDM and was working, and the way the money flowed, it flowed from HUD, why HUD is in the disaster business, that's a federal question, but HUD, and it flowed at that time through TDHCA, and then it flowed from TDHCA to the city. The way the contract was written, TDHCA did not have a contract with the program administrator. They required the city of Galveston to do it. The city of Galveston was only a conduit at this. It was never intended for, and as a matter of fact, the contract, we still feel explicitly said it is a pay if paid contract, meaning if we don't get paid, you don't get paid. CDM was to create a program to, and they were supposed to be bringing specialized software and enrollment materials to reach out to do community outreach, to get people into the program, to get them registered, to screen them because there were duplications of benefits that had to be had. If you had insurance, you couldn't get the full amount. If you to determine whether your house was more than 50% damaged, to determine whether it was historic or not, or whether there were historic damages, and that's key to this too, because we had a lot of historic homes that were not handled correctly as a result of CDM's work. So there was a whole lot of issues in that group. But anyhow, CDM was doing that. At some point, the state of Texas made a decision to move the program, or basically to eliminate TDHCA as it was at that time handling disasters, and they moved the program to the General Land Office, and at that time I think Jerry Patterson was the land commissioner. The GLO, HUD, and the city at that time were very, very disappointed in the performance of CDM, and there were a lot of folks that were still out of their homes. They were waiting on this program. Absent this program, I think a lot of people would have tried to move forward. They would have tried to repair their own houses. They would have sought other means to do it. We came out, and as part of the HUD program, we advertised we had this program. There were a lot of people waiting for it. CDM was to get it moving, and I think at that point in time, I think we had 9 houses out of proposed 1,000. Right. And this was more than a year, maybe 18 months after the event. So the GLO was very upset. HUD was upset. The city, of course, we just wanted to get the houses done. the GLO made the decision that CDM was not performing well and that they were going to put their own contractor in place and that they were going to take over the program. And at that point, the city had already paid CDM about $8 million of HUD money. There were, again, no local dollars involved in this at all. And so CDM was told, wrap it up, and whatever method Mr. Patterson's group used to choose URS, don't know how that came about. I'm sure it was some type of competitive bid, but the city was not involved in it. And they took over the program. At that point in time, the city was trying to wrap up, and we were going through, and the city's sole role was to go through the invoices from CDM, make sure they complied with HUD guidelines, and forward them to the GLO for payment. We sent some $6 million worth of invoices up to the GLO multiple times. The GLO did not pay the invoices. And we can sit here for hours and talk about the reasons that the GLO gave us to. They didn't like the color of the paper, they weren't stapled correctly, you name it. At the end of the day, my opinion is that the GLO had already committed the money to the new contractor, URS. There was only a certain amount of money in the program to pay a program administrator. So when they cut CDM off, they needed every dime that was left, in my opinion, to pay URS. At that point in time, I believe the General Land Office was no longer interested in paying CDM. We tried. They would not pay them. Of course, CDM's answer is that we may have performed poorly, yada, yada, yada. We submitted the invoices. Our contract's with you, the City of Galveston. So the crux of the court case was really whether or not the pay if paid clause in the contract was the true deciding factor here. And, of course, the GLO was, in my opinion, again, this is all my opinion, was of little help to us in this court case. Actually, there's other litigation that Mr. Glowacki will talk about that involves the General Land Office as it relates to this case. This case is far from over. And I'm not here to defend CDM. I'm certainly no fan of CDM. Probably wouldn't recommend them to another city. However, I'm not fully faulting them at this because they were doing what I think at that time they believed was right, which is submitting the invoices to the city. We forwarded them to, and performance aside, and a big part of the case was discussion of their performance, and I think anybody that was either in the program or that was around the houses that had been built or designed will agree that their performance was less than stellar.
Yeah. Now, the case that just concluded in Judge Cox's court, what is the finding was against the city?
Correct.
There is a ceiling on this judgment.
Correct.
And again, there are other court cases going on that will affect this.
And because there were a whole lot of factors in it. There was the money there was the actual dollars that CDM felt that they were owed, which is basically all of it. Considering they only had 9 houses finished when they left, but they felt like they were owed 100% of the money, is a little odd, but that was for the jury to decide. The other thing is that then there became in it, because of the time that has elapsed with this, there was the interest, and there was the Prompt Pay Act penalties and such. So at the end of the day, CDM was asking for $29 or $30 million in the lawsuit.
Potential.
And basically the ceiling now is the settlement amount, which is about $14.5 million. So in my mind, the jury split the baby. I don't think that and actually some of the questions that came out during their deliberations that came back out to the judge really indicated to me that the jury was very uncertain, and it was not a unanimous vote of the jury.
So, to put it in perspective, what is the city's total annual budget? What was it last year?
Total budget, including all funds, is about $130 million.
Okay.
But that includes all your water and sewer and federal dollars and everything else. The general fund budget is $35-40 million.
And let's do a hypothetical because people will want to know. Mm-hmm. How much cash does the city keep on hand for emergencies?
Well, we are required by charter to keep 90 days of operating cash. We usually keep over 120 days as a precaution. The city has anywhere from $15 to $18 million in cash on hand in fund balance, not budgeted at any given point in time for emergencies and such.
Okay. And what would be the general effect? Of course, we have no way of knowing if this is going to go through.
No, we have already realized, as did the plaintiff in this case, that there's some a little bit of double dipping or duplication in the settlement amount. So we feel the settlement amount, either Judge Cox or the first blush of the appellate court, will probably reduce that amount by several $1 million right off the bat. But we have a lot of options. We do have some cash available without breaching our 90-day number, because again, in many cases we have up to 120 days in there. We're required to carry 90. 90 is prudent, so with the bond companies that rate us 1.1.
And we'll come back to this, but the city essentially has the ability to pay, but there would be some service issues.
We have a lot of things to talk about here. There's post-trial interest involved as to whether we put the money into the register of the court, or whether we roll the dice and go to the appellate court and don't put any money up.
Okay.
These are all discussions that we have to have, and we won't know that for weeks now until we have a final settlement amount from the court.
Okay. Well, let's get to the court.
And we also have the ability. The city has very little debt, and there is, we're not the first city, believe it or not, to be sued, and this is far from the largest settlement against the city. So cities across Texas and across the United States have the ability to bond for these type of things. Actually, the biggest problem we have with bonding, if we had to do this settlement, is that the amount is actually small, which makes it hard for us to place the debt. Mm-hmm. Most municipal bonding companies, our credit is stellar. Our bond rating has increased dramatically since I've been here. We're AA status. We're in really good shape. That's not that big of a deal. But, again, if we were to do it through debt, and what we have to weigh out is the post-trial interest, that by not putting it in a register, if we were losing the appellate court, is that higher than the debt we would pay?
Well, let's go to the appellate court issues real quick. Don Glowowski is the city attorney. And Mr. Glowowski, could you tell the citizens of Galveston in lay terms exactly what cases, other than this one, the city's involved in?
Well,
with respect to the CDM.
The case against the city was filed in 2013. It's taken 5 years to get it to a verdict. Immediately after this case was filed against the city, the General Land Office filed a lawsuit against both CDM and the city of Galveston in Travis County, seeking a declaration that any funds for which it was judged liable would be limited to those federal CDBG funds which had been appropriated for this project. Basically, it was a claim for a limitation of liability.
That was their pay of pay, basically.
CDM filed a cross-claim against the GLO and the city has done the same. That case was abated, which means it was put on hold by the Travis County judge, who said he would take it up when the Galveston case was final. The Galveston case is far from final. We have a verdict, but a verdict has to be issued into a judgment. There are several post-verdict motions that we'll file attacking the verdict for various reasons, seeking reduction, but eventually it will be reduced to a judgment, and I anticipate that judgment will be signed late October, maybe by the latest early November.
And Judge Cox has discretion on the total amount. Is that correct?
Judge Cox has some discretion, not total discretion, but he has discretion to, through a motion called additor or remitter, to either add to the judgment amount or reduce the judgment amount. I do not see any evidence in this case that would justify an additor. However, there are some issues that could result in a remitter a remitter is a reduction. That is within his discretion. However, the evidence would suggest he should do it. If he does not do that, that will be the subject of some post-judgment motions that must be filed to perfect error, and then an appeal will issue.
Now, if everything goes perfectly, you say by the end of October you're expecting something from Judge Cox.
Judgment.
A judgment.
Signed by Judge Cox.
How long after that would you expect the court in Austin to take up the filings there?
Well, remember, their suggestion was they would do it when the Galveston case was final. While the case is on appeal, that judgment is not final. And not only do we have some appellate issues to present to the Texas Court of Appeals, there are some issues here that are ripe for consideration by the Texas Supreme Court.
So is it fair to say we're still years from a final decision with all the court cases?
I think that's very fair.
Okay. Which brings us to the third person in the room, which is Dr. Craig Brown, Mayor Pro Tem. And I asked Craig to come here rather than Mayor Yarborough for the simple reason that I believe Craig is on the ultra short list to be the next mayor of Galveston. So it's likely that it would be his council that would have to deal with this. And I know Craig's been paying attention because I was in the room with him for 4 years, or 2 years. And Dr. Brown, the one thing that the citizens want to know is that the city council's on top of things. But I also know that we can't talk a lot about what happens in executive session with regard to lawsuits. However, do you want to say a few words about the issues that have been discussed as far as plans for a worst case scenario and plans about how things might be prioritized in the budget should we have to take this hit?
Well, needless to say, as you can see from what the city manager and our city attorney has mentioned, this is still a complicated situation. We're still not sure what the exact judgment will be. That has a bearing, of course, on how much money we may need to come up with or not. Also, we've got the case in Travis County that's mentioned. If we prevail in that case, that may bring in monies from the state or the GLO that would help with this judgment situation. So council is really going to need to sit down, and I think this is the time that we need to really sit down and have a thorough discussion, not only with our legal department, but with city staff. The prioritization of what services, if any, in the future would need to be curtailed in some manner to cover these type judgment payments. That's something that will be guided a lot by city staff, and we haven't entered into those discussions as yet. I suspect that those will start up probably as we get a little closer to the end of this month, or end of October, 1st of November, when the judgment comes down.
Okay, great. Thank you. Now, finally, back to the city manager. I have one question, then I'll let you wrap it up.
Okay.
The question is, are these discussions with city council on any kind of contingency going to be taken in workshop, in public, or will they have to be part of the executive session by necessity?
Probably both. We certainly don't want to talk strategies in an open session, and a lot of what we do with the money is a strategy issue. However, anything that would have any impact on the citizens would certainly be discussed in open session. I will say this at this point. There will be, and we are taking steps as early as today to begin to work through what we feel will be needed to fund any future endeavors that result from this. And and this is not new. We've been talking about this, as Don said, for 5 years. So the city has made some preparations for worst case scenarios. But we're going to be taking some action at this point. There will definitely be changes felt within the city meaning within city staff and within city departments. But I think as far as the citizens are concerned, at this point, I'm not seeing anything that would cause a reduction in services or any curtailment of our capital improvement program. There's a lot of protections granted to the citizens in the charter, and the good news is that doesn't really impact it. It's an unfortunate situation. Again, I'll say it again. I probably wouldn't recommend CDM, although I don't know if I'd recommend any firm to do these post-disaster type things. We have other relationships with CDM that have gone very well. They designed the new sewer treatment plant on 51st Street, which has served us well since it's opened. So we have had some very good relationships with CDM. I had somebody ask me the other day, would we do business with them again? And my answer was probably not in the realm of disaster recovery. But you never know in terms of the other, because we do, they have some very strong talents in those areas. So, but at this point, Norm, if I were a citizen in Galveston, I'm not seeing any of this that's going to have an ultimate impact on them at all. There will certainly be some changes felt and some, I guess the proper word will be belt tightening. I don't know if that's something a fat guy should say, but there'll be things like that here at the city that we'll be undertaking. And the good news is this is hitting us right at a change in a fiscal year with a fresh budget, so we're able to make those changes.
Great.
But certainly no adverse impact via taxes. And at this point, we are going to do everything we can to not curtail any services and to handle this. So the good news is I think we're represented well with our council with an S in this case. We are going to be represented well, I feel, in our appellate case. And I have a great deal of faith in Mr. Glowacki. I've worked with him for many, many years and has a great amount of knowledge as these things move through the case. We're grateful to Judge Cox. We're glad he got to see his Astros game. When you talk about regrets in life, one of my big projects was the Justice Center. And as I look back now, I wish, as we were building the Justice Center, that I would have put just a little bit more padding in the seats, in the pews after sitting there for 2.5 weeks. It's not good. It's never good when you get a settlement against you like this. But the good news is in many cases, what we're doing here at the city right now is we're preparing it for the long haul. And the long haul includes such things as getting hit by lawsuits. It includes by getting hit by hurricanes. And, I would say that this happened to us, even before Ike at the city. This would have probably been a lot more devastating case. But with the work of your council, they have bought into the fact that we're building Galveston up for the long haul. We're making a lot of decisions now that have relatively, may even have some negative short-term impact, but have tremendous long-term positive impact in the city. And it's because of that we're able to deal with these things.
Great. Well, gentlemen, I want to thank
you. And you were part of
three
that, Norm. Let me give some kudos to Norm. Norm was part of that. And so...
Well, thank you.
And that's a big part of it. I wish Sam was here because he's an Aggie and he would better understand. But we appreciate you being here, Norm.
Love Sam, and thank you for your kind words. But thank you all three of you, for all the work you do for the city. And we'll be back to talk more about this and maybe other things as they come up. And I want to thank you for your time and dedication.
You
Take
bet.
care.
Thank you so much.
Thank you, Norm.
Thank you.
All right, Meet in the Middle Chronicles signing off from Galveston City Hall.